Okay. Good morning, everyone. My name's Joe Weiler. I'm Professor Emeritus at the Peter A. Allard School of Law. I'm co-director of the Anti-Corruption Law Program, along with my friend and colleague, John Ritchie. Welcome to the fifth monthly webinar of 2021 of our program. The Anti-Corruption Law Program is really a working partnership of the Center for Business Law at the Allard School of Law, Transparency International Canada, where I have the pleasure of being vice chair, and the International Center for Criminal Law Reform, whose office is located at UBC. So this is the 25th session since we got going 5 years ago of our program. We had none in 2020 because of COVID, and all our programs prior to that were face-to-face. So, and now this is the fifth webinar that we've been on this year. So the three organizations that I mentioned, all of them were doing important work separately in the field of anti-corruption, but we decided that they would take collective action and capacity building through continuing professional education, and pull together the expertise and resources of the three organizations to combine with this program, all of which is designed to bring together experts like we've got today so that we could teach each other. They could teach each other and they could teach us about the best ways of fighting corruption. So special thanks to Dr. Carol Liao, who's the director of the Center for Business Law, and her technical team, Austin Darling and Stephanie Lee, for doing all of the things that make this happen. So the panelists like ourselves and the organizers who know very little about these technical things can simply stick with content and let them handle it. So very appreciative of the Center for Business Law, because they've helped us to bring the anti-corruption law program to a totally new level. And special thanks, I would say, to Norm Baldwin. Norm is a colleague of ours in the core working group of the Anti-Corruption Law Program, but Norm really took the lead in organizing today's roundtable. And he's got just an amazing panel from Canada, the UK, and the United States. So thank you, Norm, for all the work that you've done to put this together. And welcome back to Jordan Thomas. It was 4 years ago this month, actually, that Jordan also was part of a anti-corruption law program on whistleblowing. So 4 years later, it's high time that we revisited this topic, but we're in a slightly different format today, though. Anyway, welcome back, Norm. So the format today is a roundtable. Prior to this, we've had our panelists give a short presentation and then a Q&A format. But today, it's a roundtable, and it's designed to increase the engagement among panelists and between panelists and our registrants. So, we're going to try it out and hope it works. So, and special thanks to Professor Alexander Komarov. Alexander is on a Fox Fellowship. He's visiting UBC from Yale, where he was last year. But he's from Ukraine, and where he practiced law and taught law in the area of anti-corruption. And Alex has prepared a briefing note, which is posted on the ACLP webpage on the Center for Business Law website. And it's a comparative law briefing note that compares the legal systems that support whistleblowing in Canada, the United States, UK, and the EU. So please have a look at the briefing note. It'll help you to understand the context of today's session, and it's posted there for your convenience. So thank you, Alex, for putting that together for us. And finally, it's my pleasure to introduce the moderator for today's roundtable, and that's Emmy Babalola. Emmy's a partner in Deloitte's forensic practice. She leads Deloitte Canada's whistleblowing service and workplace conduct practice. She's a chartered accountant. She's a certified professional accountant. She's been qualified as an expert witness at the Ontario Superior Court of Justice in the area of forensic accounting and fraud investigation. So we're very grateful that Emmy's agreed to take the role today as moderator. And I just want to thank in advance all our panelists for taking the time to engage with us today. We're very appreciative and we're looking forward to today's session. So thank you, and over to you, Emmy.
Thank you so much, Joe. Hopefully everybody can hear me okay. Can I get a thumbs up from anyone? Great. Okay. Wow. Good morning, everyone, or good afternoon to those joining us from the East Coast. It's my pleasure to be here today to moderate what promises to be a very lively and insightful discussion on whistleblower protections, abuses, and reporting systems. So as Joe alluded to, we have assembled an all-star panel for today with a vast range of experience, including securities regulation, advocacy, provision of whistleblowing systems, in-house users of these systems, as well as legal expertise with respect to whistleblowing, including privacy considerations. So without further ado, I would like to introduce you to our panel of experts that you'll hear from today. First up, we have Jordan Thomas. Jordan was a principal architect of the SEC Whistleblower Program and served as the Assistant Director of the SEC's Enforcement Division and as a trial attorney in the DOJ's Commercial Litigation Branch. Jordan has represented clients in numerous whistleblowing cases, including the largest single case whistleblower award in history, as SEC whistleblower to receive criminal immunity, and the first SEC whistleblower to receive an award on account of retaliation. So Jordan, welcome. Our second panelist is Mary Inman, and Mary is a partner at Constantine Cannon, where she splits her time between London and San Francisco. Mary has spent over 20 years representing whistleblowers in the US, UK, and Europe, as well as worldwide, particularly with respect to the American Whistleblowing Reward programs, including Tyler Schultz, the Theranos whistleblower. Mary is on the advisory board of Whistleblowing Canada Research Society, a nonprofit organization aimed at improving whistleblower protections in Canada. Welcome, Mary. Our third panelist is Paul Townsend. Paul is based in Vancouver, is a certified internal auditor with over 30 years of experience in risk management, audit, and compliance. Paul spent 16 years with TK Group, one of the world's largest marine energy transportation companies, as Chief Risk Officer and Chief Compliance Officer, leading a global team in anti-corruption compliance and investigations, as well as having overall responsibility for the company's whistleblower program. Paul now advises organizations on enhancing their compliance programs, including implementation and operation of effective whistleblower programs. Welcome, Paul. Our next panelist is Sandy Boucher. Sandy is a principal at Grant Thornton's Forensic Practice in Toronto and has 37 years of experience conducting fraud and corruption investigations, international due diligence, and asset tracing and recovery cases. Sandy also leads Grant Thornton's whistleblowing offering and is an expert on developing whistleblower systems and working with whistleblowers. Welcome, Sandy. Our fifth panelist is Anka Sattler. Anka is counsel at Dentons in Ottawa, where she advises clients on privacy compliance, cybersecurity, and data protection issues, particularly as they relate to whistleblowing, as well as implementation of whistleblower policies and procedures. Interestingly, Anka has lived in Canada, the US, and Europe, and works in 5 different languages. Very impressive. Welcome, Anka. And last but not least, our sixth panelist is Michael Scott, who is the Director of Compliance and Investigations at the Real Estate Council of BC, which is the public sector agency responsible for regulating the real estate profession in British Columbia. In his current role, Michael is responsible for the whistleblower reporting system and case management, and he has over 20 years of experience with law enforcement, including experience in the RCMP, as well as experience in the private sector at Scotiabank and WSIB. Welcome, Michael. So as you can see, we have a real wealth of expertise and experience both within Canada and internationally on the panel today with respect to whistleblowing protections, abuses, and reporting systems. So having introduced the panel, I'll just give you a heads up as to the structure or the format for today. I'm going to be leading the panelists through a series of questions designed around particular topic areas. But of course, if you have questions that you would like to ask, we'd like you to feel free to do that throughout. You can use the Q&A function within the Zoom platform. I will prompt you when we are moving from one discussion topic to another in case you may have a question that you haven't had a chance to ask yet. So either shoot them out as we go, or I'll prompt you as we switch discussion topics. And just one administrative note, you might want to refer to the briefing materials that Joe referred to in his opening remarks. Lots of useful information there and some background information on some of the legislative differences. So feel free to peruse that if you haven't already. So with all of the administrative details out of the way, then I'd like to kick us off to the panel discussion. And we're going to start the discussion topic around the whistleblower programs, incentive programs, so specifically within the US and internationally. So Jordan, I'd like to start with you. Given that you had a leadership role in establishing the SEC Whistleblower Program, and you now represent SEC whistleblowers, can you provide us with a general overview of the program to kick us off today?
Sure. The SEC has the SEC Whistleblower Program has three primary pillars. The first is the ability to report anonymously. The second pillar are enhanced employment protections. And the third pillar of the program is the ability to receive monetary awards. Under the program, whistleblowers are entitled to 10 to 30% of the monetary sanctions collected, which can be quite significant, considering the SEC collects approximately $4 billion a year. And you also can receive the same 10 to 30% for related actions. For instance, if there is a FCPA case or foreign bribery case, and the SEC and DOJ brought enforcement actions, you would be entitled to 10 to 30% of the SEC case and 10 to 30% of the Department of Justice case if the monetary sanctions in the SEC case exceeded $1 million. You can also apply to multiple programs. Mary, I'll talk to you about some of the other programs, but it's not an or choice. You can apply to the SEC program and then apply to other programs because the same facts might actually trigger different types of violations. So that's a quick overview, Emmy.
Thank you for that. And can you share with us a little bit of detail about why the program was structured this way? So in particular, the incentive aspect of the program.
Sure. So these programs were established following the financial crisis and the Madoff scandal. Those two things together were kind of the motivating factors. What was clear to the financial watchdogs was that the status quo wasn't working. Anti-retaliation laws alone were not enough to get people to break their silence and report significant problems, especially among those senior, highly compensated, and knowledgeable individuals in the financial services industry. There's a lot of debate about whether that was smart. Most people like the idea of people reporting because it's the right thing to do. But ultimately, the SEC and later the Ontario Securities Commission chose to focus on the reality that we faced in regulating the markets. We also appreciated the problem that awareness was widespread in the marketplace, but few people were coming forward. There are some very powerful surveys that we saw and since have followed up on. We don't have time to cover them here, but I would encourage people to look at the University of Notre Dame and Labaton-Sucharo Financial Industry Survey. Just a few kind of key findings is that 47% believe their competitors were engaged in illegal behavior, 23% believe their colleagues were engaged in illegal or unethical behavior, and 22% said they had firsthand knowledge of wrongdoing. Very significant numbers. And the other survey findings that were troubling, so you have lots of people that know about the problem, the status quo is not working, and then there was a distrust among employees about reporting internally to their employers. And so with that, we were forced to ask the question, how can we create a program that's compelling for people to come forward. And ultimately, we landed on the three pillars I talked about at the beginning.
Thank you for that. And Mary, just sharing with us some of your international experience with respect to some of the incentive-based models. Can you share with us what some of the details are that relate to other programs around the world? So what information do we have about incentives and payouts and awards to whistleblowers?
Sure. It's been my pleasure to start in this area of law 24 years ago when it was just the False Claims Act. We're going to talk more about the False Claims Act, but that's the original. So that's the grandmother of our whistleblower programs, where it not only allows to do what it goes farther than the SEC program, which is a tip-based program that Jordan was describing, where you launch a tip. The False Claims Act actually allows you to launch a lawsuit, be the plaintiff in the name of the government, which is an extraordinarily powerful tool. And it's really the success of that program. It's called Lincoln's Law. It started, the history is quite interesting. It came from English common law. And as I'm practicing in London, they say, as a cheeky American, I take that program and try and sell it back to them as mine. But I'm very good on attribution. We stole it from them. It stands for Quitam, he who stands in the name of the king as well as himself. So it's very interesting history. But since 1986 to present, when the act was amended and invigorated, it has returned over $46 billion to the US Treasury as a result of whistleblower initiated actions. Those whistleblowers have received $7 billion as a result of that, and that represents 17% of the total recovered. So I would say that that's a good return on investment for the US taxpayers. But it's that program and those statistics that inspired the SEC and now a whole host of additional agencies based on the success of the SEC program has gone on to do additional tip programs. So we have Jordan to thank for helping us get that. And we do view the SEC program as the gold standard. But even still, the IRS has a program. The IRS, our US tax authority, has recovered $6.14 billion as a result of whistleblower initiated actions. Those whistleblowers have been paid $1 billion in rewards. So it's clearly a model that works. And now it continues to grow. The corollary to the SEC program is our Commodity Future Trading Commission program. It has equally impressive statistics. As a result of the Takata airbag scandal, Senators Blumenthal and Thune pushed for a motor vehicle safety whistleblower program. We actually represent one of the first whistleblowers coming from South Korea, who was bringing information about Hyundai and Kia with engine seizure problems, and helped impose a $210 million fine. So it's really showing that, in a global multinational sphere, the people who can help government agencies in the US exist everywhere. And then finally, this year, the Treasury Department, as a result of the FinCEN files investigation, which was a BuzzFeed's and ICIJ story, we adopted a reward program in the Treasury Department for money laundering, so violations of the Bank Secrecy Act. So that is just starting to show that this has really caught on, and the success begets success. I don't want to leave out Canada because the Ontario Securities Commission, as Jordan well knows, has its own program. It's about 5 years old. It's returned $8 million. It's paid $8 million in awards to whistleblowers. The interesting distinction is that unlike the US programs, where the range that a whistleblower can receive is 10 to 30, under the Ontario Securities Commission, it's 5 to 15. It's a bit more modest. And there's also a cap on the amount that the whistleblower can receive. But the data that I think is most telling is that Jordan and I both look very closely at the end of each year. The SEC and these other programs do reports to Congress on the success and the data from the past year. And we've been tracking that data year over the year for the past 10 years. The SEC looks at what countries outside the United States supply the most tips to the SEC program. Year over year, it had been the United Kingdom. And in the past 2 years, Canada has outpaced the United Kingdom as the number one. And my armchair psychologist view on that is because, and I hope Jordan will agree with me, that with the advent of the OSC program, I think people are now in Canada are understanding more about the SEC program, because as Jordan said, you can bring both actions if both sets of investors are harmed, the American and the Toronto folks on the Toronto Stock Exchange. So that's just a nutshell, hopefully a whistle-stop tour of the many programs. But I should also add that looking across the pond, South Korea has one of the strongest and oldest tax whistleblower programs, 50 years old. And we're starting to see flirtations. Jordan has testified in Australia and other places where there are strong flirtations to adopt, and the UK to adopt comparable SEC type programs, and we've gotten close but no cigar. And right now there is legislation in the UK to take a second look at that, and we'll see if we're successful. So that's the overview.
I would just want to add a thought, is that since the SEC Whistleblower Program has been established, Canada has consistently been in the top 3 countries to report to the US on US law. One can only imagine if Canadians were given the opportunity to report on Canadian violations of law, just how many of folks would come forward.
Thank you both. So lots of great reasons there, and lots of support for the incentive-based model. Would love to hear from you, Mary, about some of the securities commissions that aren't currently using an incentive-based model. So notably Quebec, Alberta, and BC. Any thoughts on why those models were implemented and how they're working as well?
It's interesting. Jordan may have more information than I do on this, but a colleague of both of ours, a gentleman by the name of Greg Krakauer, who used to work, and he was instrumental in getting the New York State False Claims Act adopted. He testified in front of the Charbonneau Commission, which, as folks I'm sure are aware, a big concern out of corruption in the construction industry in Quebec. One of the things that was floated there was the idea of a False Claims Act, and Greg went to testify, and I believe that Jordan himself has testified at least in one of these. And I think, as to you were asking about the securities programs, but I think in addition, the False Claims Act was something that was proposed there. There's a professor from Paul Daly from the University of Ottawa, who basically his statement and his paper said that there actually would be a legal basis. There's a question whether you could bring a civil fraud statute like the False Claims Act, and his research said yes. I think it's a scary proposition to allow individuals to launch a lawsuit in the government's name. So I think that may be one piece of it. I also think there's strong cultural impediments to rewarding whistleblowers. My experience in the UK, another Commonwealth country, the original Commonwealth country, very much a sense that it is somehow tawdry or unseemly to pay whistleblowers, that you should do it because it's the right thing to do. And I think a lot of what we recognized is that my clients don't necessarily do it for the money, but the money is something that helps them in the tipping point when they're deciding. The repercussions are so profound that you can be blacklisted, that those retaliation protections that Jordan talked about, they only help you as to that first employer. But it's the subsequent employers and the subsequent blacklisting which can make it, a life-altering, career-destroying decision. And so we often talk about the rewards as the net present value of a career loss. It's not a bounty. But I think a lot of it, because Americans, rightly or wrongly, are perceived as mercenary and capitalism unchecked, I think there's a knee-jerk reaction to that. Americans pay everyone to do the right thing. So it's very, it's loaded. It's very culturally loaded. And I think the more we can get behind it, and actually when I have these discussions, I cite in the UK, I cite the Ontario Security Commission program by saying you can make it your own program, you can lower the range of rewards, and you can put a cap on it and make it your own. But I think that in some of these, it's just been a little too soon. But I'm confident Jordan has a view on his work there.
I do. I've spoken at the House of Commons and testified before the Ontario Securities Commission and the Australian Parliament on these issues. And what's very clear is that there is a better lobby for business than there are for investors. And there is a fundamental concern, as Mary talked about daubing. We just don't like to encourage people to daub. And but what people fail to understand is, and in some ways, regulators are torn. On one hand, they're concerned about people in the financial service industry taking huge risks and compensated for that risk. But then when individuals are taking huge risks to expose wrongdoing that impacts investors, people then go, whoa, 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 we're concerned about you being compensated for this. But ultimately, in the US, I joke that if clown costumes were effective in law enforcement, we would have our law enforcement with people wearing clown costumes. And people in the UK prefer not to wear clown costumes and are more comfortable with their investors getting taken advantage of.
And how successful has the SEC program been, Jordan?
Great question. So there's lots of different ways to look at it. Let's look at it quantitatively. There's been more than 40,000 tips from all 50 states and over 130 countries. Approximately 10% were submitted from foreign jurisdictions or foreign nationals. They've launched more than 1,000 investigations. They've led to over $3.1 billion in monetary sanctions, including $1.8 billion in disgorgement of ill-gotten gains and $850 million that's been returned to investors. Just to give you a sense of how important the program is and could be for Canada and other countries, is that the CFTC, more than 30 to 40% of their current active investigations are the result of whistleblowers. So the question for other jurisdictions is, would you like an extra 30 to 40% of cases? And understand, that meant that the 30 to 40% of cases that the whistleblowers brought were better than the 30 and 40% that the CFTC was working on before whistleblowers showed up. But to me, looking at the success of the programs requires you to also look at it qualitatively. Investigations are more effective and efficient. You no longer have to work your way up the institution, because whistleblowers are providing targeted information and telling you who was involved. More individuals and senior executives are being charged. From a corporate perspective, it's less expensive to respond to regulators' inquiries because, again, they're targeted. So you're not having to let the regulator do a lot of fishing. Other things is that there's also been a power shift in the United States because the power of the probability of detection. Now, everyone's worried about is someone going to report this? So companies are self-reporting more often to the regulators. If you are a potential culpable participant, you're worried that someone else around you is going to come in and report, or someone who knows about it. In-house legal departments, compliance personnel, and gatekeepers like accountants, lawyers, and others also have been empowered because they can now go to their entities and say, we need to invest more in these reporting and compliance programs because otherwise they're going to report externally. And if in fact you're aware of a problem, there is a greater power to sit there and say, I can't remain silent because somebody is going to tell the regulator. There's just too much incentive out there. Just to give you kind of proof of how powerful the program has been at the SEC, post-COVID, there was a 35% surge in tips relating to COVID-related frauds and other related frauds. So these kind of very timely reporting. But the best evidence is if you look at the task force that was focused on climate and ESG issues that was announced in March of 2021. That was a high-profile initiative at the Commission, and whistleblowers are prominent in the press release. And it's smart. They're telling whistleblowers we're interested in this. Please call us. And they're also saying our plan for being successful in this high-profile area is leveraging whistleblowers. So that gives you a feel for kind of the power of the whistleblowers and their impact in the U.S.
Thank you for that. So many great stats that you shared there. People are obviously incentivized to come forward when they have information. As we know, that doesn't always turn out so well for the whistleblower. Can you share with us how the SEC program protects whistleblowers from retaliation and blacklisting?
Sure. So one note, because I think it's important. In my experience, and I imagine Mary's experience, the number one indicator that someone is going to report externally is if they were retaliated against or perceive that they were retaliated against. At that point, it breaks the tie with the organization, and at that point, they're recording conversations and taking documents out the back door. Anyway, to answer your question, the way the program has worked to address this, ability to report anonymously is the best protection against retaliation and blacklisting, because if they don't know who you are, they can't hurt you. The commission also, if you are suspected or known and then are retaliated against or blacklisted, the SEC has enhanced the employment protections that exist for whistleblowers. I think that it's also important and not as fully appreciated that the SEC through this can also bring enforcement actions against companies that retaliate against whistleblowers. Normally in the employment context, and I don't want to make my employment colleagues sad, but it's a David and Goliath dynamic. You know, you got the big company with a ton of money, and you got the little employee trying to right the situation. And in some countries, I can't remember what the situation is in Canada, loser pays. So you have this even bigger problem for these folks to come forward and kind of try to vindicate their rights. Well, because of the SEC whistleblower program, the SEC can charge a company with retaliation against an employee for reporting a possible securities violation. So now the whistleblower has a very, very big brother behind them who's willing to help protect them. And it's not an or situation. They still can seek their traditional employment remedies, and the SEC can punish a company for retaliating against them. And having represented the first whistleblower whose company was charged with retaliation against them, I can tell you the SEC takes this very seriously. And the other aspect of it, which is particularly satisfying to whistleblowers, is most employment resolutions are non-public. So you're fired, but no one knows why. No one knows that you were wrong. There's no kind of public vindication. When the SEC charges companies, it's always public. And so you may not be named, but the company is being called out for what they did. So down the road, my client in the Paradigm Capital Management case can point to and say, look what they did to me. They told me see something, say something. I reported it, and then they rolled a bus over me. It's not I'm a bad employee. The rumors they put out in the market about me aren't true. I just did the right thing.
Thank you. And Mary, anything to weigh in from the international perspective?
I think the interesting thing that I've learned is I think people are used to there being an idea of American exceptionalism. And I think we can be exceptionally good at things, and then we're also exceptionally bad. And one area where I think we have a lot to learn from the EU for their whistleblowing directive, and even from the UK, is that our retaliation protections are siloed. So you get it under Sarbanes-Oxley, you get it in the SEC and CFTC, but there's no umbrella retaliation protection law like there is in the UK and the Public Interest Disclosure Act. I don't want to cite the Canadian law because unfortunately in a review that the International Bar Association and the Government Accountability Project did of all of the whistleblower statute, they ranked Canada's whistleblower protection statute last. So I'm not sure we can point there, but the EU Whistleblowing Directive has now required 27 member states to have retaliation protections where only eight countries had before. But the reason I think it's notable is that unlike the US model, and there is now a shifting of the burden of proof, as Jordan said, it's a David versus Goliath, and the David, not under the American programs and traditional employment law, the whistleblower has a burden to prove that they were fired not because they didn't have their expense reports in on time, or not because they were chronically late, but because they were whistleblowing. That's a hard burden to prove. That has been shifted in the EU directive, and the Ontario Securities Commission's retaliation protections similarly shift the burden of proof. And I think that's a great development. So now the onus is on the company to prove that they didn't retaliate. So I think we're making progress, but I feel like the US has a lot to learn on retaliation protections, or a lot to learn from the SEC and a lot to learn from our friends overseas and to the north.
Thank you both. A couple of questions that have come through from the audience that I'd like to direct to both of you or any of the other panelists that would like to weigh in as well. The first is, do you think it is appropriate to introduce a rewards program when a country is struggling with implementing the Protected Disclosures Act and currently in dire need to address ethical leadership in a country? This is related to South Africa.
So I think that they can and should run on parallel paths because they're trying to address different problems. Kind of from a legal perspective, I certainly see that. One of the things that I would have a concern about, and I'm sure Mary and others would have a concern about, is the safety of reporting. In the US, despite our flaws, there is a general sense that you can be safe when you go to the authorities in these sort of contexts. So if you're reporting to the SEC, people aren't worried about someone putting a hit out on you, okay? It's unclear in certain countries whether the people running these organizations are operating with integrity, and that poses problems. When speaking at a UN event, that similar concerns were expressed by some countries, is that how can we get the trust of people to come forward, and how can we ensure that in a subsequent administration that people might be in harm's way? And that's something I'd be concerned about. But I think for the public and investors, the better choice of action is to encourage people to report wrongdoing so that there's a chance that the right thing can happen.
I agree. And just would add really quickly that, whistleblowers blow the whistle because they want something to be done, right? They want to alert the wrongdoing. And the fact that the laws are focused on the rear view mirror of protecting you in the inevitable event that you get retaliated against only protects you so far. It doesn't get at the forward looking issue, which is the whistleblower wants it to go to the authority who can correct it. So I think I think every country should have that. And even the EU directive is starting to look that way, trying to require the receivers of the information, the government entities, to do something. So I think that's a necessary piece of it, because otherwise the whistleblowers signaling and blowing the whistle is in vain.
One other thing I would note is that how people report in a country tells you a lot. Like some countries, they don't report to law enforcement, but they report to certain journalists, and that tells you something about what people believe to be safe. But I think Sandy was going to say something.
Sure. You made a point about parallel, Jordan. Thank you. I think it's important to remember that all of these paying systems, as great as they are on the models and the learning and how far ahead they are, there are lots of industries and there are lots of circumstances where those kind of models just won't work. And like many of our provincial and other laws, so in government scenarios and in public company scenarios, it can work really, really well. It's awesome. But in other places and in other countries, there are millions of employees that work in industries where they may not work. So I think it is good to develop these, but it may not be the only answer. And having parallel systems to protect other industries and other kinds of employees is also going to be important. In other words, not the only answer. It's a great answer for the segments where it's going to work.
There's no question that models need to adapt. I think Mary mentioned that, pointing to Ontario as an example, how they did something different. I think that like for instance, some countries, the monetary sanctions tend to be relatively modest. And so getting a percentage of the monetary sanctions may not be meaningful enough. Sometimes it's where you're getting the money from, because if you take money from the agency, they can't put cops on the street. So there are certainly challenges, but what I believe strongly is whistleblowers are the most effective and efficient method to exposing wrongdoing. And you know, you can for one cop, the amount you pay one cop, you can have 10 whistleblowers, and they can expose so much more. And so I think that we should be looking for ways to get whistleblowers to come forward.
I don't want to keep, I want to make sure we get to other people, but I just should say that I definitely agree in that. But one of the limitations, as Sandy is pointing out, is it requires a regulator to impose a fine and to be aggressive, right? And so I think the worst thing is to put incentives in place to encourage whistleblowers to stick their necks out, their head above the parapet, only to have the agency and prosecuting authority do nothing with it. So I think there definitely is there's an ecosystem that it has to exist in for it to work.
Yeah.
Thank you all. A few other questions coming through the Q&A. Are the limitations of provincial SECs in Canada manageable, or does there need to be a federal SEC? So we'll just say securities regulator.
Well, I don't know whether Anchor would weigh in. The whole issue of federal securities regulation in Canada is a red flag. It's probably a channel we don't want to go down today. We know that some of the other regulators are working on whistleblower programs, and some have gone. The OSC obviously is really working hard on protections, and I've got an enforcement action where they find the company for retaliating against whistleblower. And we've got other securities regulators in Canada who haven't gone nearly as far down that road. Things like the reverse onus, which Mary talked about, which is a huge and vital piece of protecting whistleblowers, are just not there. So the reality is, again, as Mary said, the laws we have and the way they're being used in Canada right now are not working well. And we have an awful lot to learn from all these other countries, in particular the US, about how we can improve them and bring them up to what we now see as global best practice. A lot of the things that have happened, there's clear global best practices, and we've got one glimmer that reverse onus of proof of retaliation is one small thing in one province. We need it right across the country.
I just want to note that in Canada, we see a big problem where people are coming to us with really significant cases, but it's in the wrong province. I can't tell you how many people come to me with TRC problems that in the TRC market, and I sit there and say, if you want to be a patriot, you can call people, and I'll help you put you in touch with people. But there's not a program for you there. So even if there were common understandings among the regulators, there would be a way for whistleblowers to kind of get the word out, but the risks are high and people are often in the wrong jurisdiction.
It also depends greatly on the powers of the government. The federal government having the power over certain industries or certain companies or organizations, whereas the provincial would have over others. So you can't really. It will be hard to generalize and have a federal one that would take or oversee everything in Canada. It may have to be segmented at the federal and provincial levels.
Thank you. More questions coming in through the Q&A, so we'll just pause to deal with a few of those. Is there any evidence in countries to suggest that protection is not only directed to the whistleblower, but also to provide protection to the whistleblower's families? Because most whistleblower laws are directed to an employer-employee relationship.
I can jump in at least as to the EU directive, and it has gone much broader in defining who is an employee, and it goes to their families, recognizing the knock-on effects, but also could be extended. I just wrote a paper for the European Federation of Journalists that I think it also protects the journalists. So the knock-on effects that we often say whistleblowers sadly are radioactive, and those who deal with them often suffer the consequences. So yes, family members are absolutely included, at least in the EU directive.
And there's a great example here in Canada where we should have that and we don't. If the Ontario COVID-19 Long-Term Care Commission didn't allow anonymity for people that provided information. And they've got a really interesting paper they put out about who was reporting to them. In many cases, the workers in the long-term care homes, where thousands of people died, were too scared to do anything, and there was no mechanism for them to do anything. And in many cases, the family members were coming forward, and the family members were saying, this is a really big problem, you need to do something. And they went to the patient ombudsperson, and they were scared to identify themselves because that could identify the actual whistleblower. And the commission went back to the Ontario government and said, we really need to find a way to get at least anonymity for the people that talk to us. And so it's very clear that in this country, in this COVID thing, that there were impacts and there were family members that needed protection, but we are nowhere near that in our legislation right now. We've got a long way to go.
Thank you. So that is the questions that have come through to date. Just pivot slightly to a different but related topic, Mary, you've alluded to it so far, which is the False Claims Act. And I'm wondering, you did provide a bit of an overview before. I'm wondering if you could just sort of give us another quick overview of the Act so that we can ask a few more directed questions on that topic.
Sure. So I was saying that the False Claims Act is Lincoln's Law, and it came about, it really deals with procurement fraud, people who are defrauding the United States federal government. And so it was unscrupulous contractors selling gunpowder cut with sawdust to the Union Army that started it. You sort of flash forward to 1986 when it was amended, and it was defense contractors selling on government contracts hammers and toilet seats for $800. So it is directed very narrowly, but widely, depending on where the federal monies go, to any place where you're submitting a false statement that moves the government to pay money from its fisc that it otherwise wouldn't have. So it's really a civil fraud statute. And I think so it covers everything from big areas where the United States spends money, of course, is in defense and in healthcare. So we don't have, with very small slivers, we really don't have a national health service. So a lot of healthcare fraud is, that is something that whistleblowers are particularly good at pointing out. So they've been really effective, and we've seen off-label marketing. Some of the biggest settlements that the Department of Justice has attained are as a result of whistleblowers. I showed you the figures of $46 billion. A lot of that has been in some very big healthcare fraud cases. But what I think is most notable is that, again, the success of the Federal False Claims Act has spawned 31 states in the United States to get in on the act. And they have false claims acts as well to protect their state and municipal fisc. So, and there are actually 8 municipalities and counties that have done the same. So it's really rather remarkable because it recognizes what Jordan was saying. The Department of Justice will echo what Jordan says, and many of their leaders say whistleblowers are our #1 enforcement tool. So it is a recognition that there's no substitute for an insider, a well-placed insider, although there can be, you don't have to just be an insider to basically provide a roadmap to the fraud. But what is so remarkable, and why I think we need to focus on the distinction between the False Claims Act and the SEC program, is that, as I said earlier, the whistleblower gets to launch a lawsuit in the government's name. That has been held to be constitutional by the United States Supreme Court because really the statute goes back to the founding fathers. Even Scalia, our strict constructionalist, basically said, yes, it is, even though the whistleblower themselves doesn't have the traditional standing, that hasn't been personally harmed, they actually are empowered to stand in the shoes of the government to launch a claim on their behalf. They're pretty much deputized as attorney generals or prosecutors. So remarkable power. And what that brings, which is something that the SEC and other agency programs can't can't claim is that it brings the support of the lawyers behind those whistleblowers. So we can actually, whistleblowers, the most successful cases are cases where whistleblowers launch the case is filed under seal. The government gets to decide if the whistleblower investigate the allegations without the defendants knowing, see if the whistleblower's claims can be corroborated. And if so, then they can join the case, take over the case, and then we proceed in parallel, supporting the government. So what I mean by we is that there's a private bar of attorneys who can actually supply our resources to help get at the imbalance of power in so many of the cases that the government faces, right? They're just an overworked, underpaid public prosecutor now has a bench behind them of some private, properly incentivized attorneys to help bring the case, to help write the motions and defend depositions, review the bucket loads versus of documents that are thrown to them. So it's really seen as a public-private partnership. And I think that's one of the most powerful parts. And the interesting part is that the attorneys' fees issues that the attorneys to help incentivize more firms like mine, like Jordan's, to take these kinds of cases. The defendants have to not only, they take the American rule where most people, each side of the conflict has to pay their own attorney's fees, and they turn it on its head. And there's an exception saying that the defendant, if you're found guilty, if there's a successful case against you, then you have to pay not only your attorney's fees, but the attorney's fees of the whistleblower as well. The last thing I will say is that yesterday, to try and bring us topical, Senator Warren earlier this week was pressing for a key TAM mechanism for the IRS. So as I was saying, the IRS program right now is just a tip-based program, and she's proposing in with what President Biden is looking for $80 billion to sort of reinvigorate the IRS. One of the models that she's pushing is to allow whistleblowers to launch these lawsuits in the government's name.
Thank you for that very, very thorough summary. And anything to add from an international perspective as well? Are there other jurisdictions that have similar or comparable laws in place, and are they as effective?
So we really stand alone in the False Claims Act. And one of my favorite topics in the UK is to say, this is to push them, because they actually go farther than we do in some respects. They have private prosecution ability. They have people who are able to bring private prosecutions in criminal contexts, but they don't have the equivalent of a False Claims Act. So we really are unique in that respect. And I don't really know of many, besides the Charbonneau Commission, I know of very few instances where other countries have considered the idea of the False Claims Act. There's been lots of folks considering the idea of a tip-based system like the SEC, but not one where you empower the whistleblower to be a party to the action.
Thank you very much. Any other comments from the panelists? We're going to shift to a new topic area to cover private sector whistleblower hotlines and other reporting systems. And also any other questions from the audience at this time. Okay, so moving on then to a different topic area. Thank you, Jordan. Thank you, Mary. Of course, feel free to chime in as we progress with some of the other discussion areas. The next question I'd like to direct is at Michael. And I'd like to ask what resources need to be directed at these reporting systems so that they are viewed as credible recipients of reports of wrongdoing and robust investigative and sanctioning vehicles. So again, looking at this more from the reporting system that a private entity would put in place.
Yes. Thank you, Emmy. I hope you can hear me.
Loud and clear.
Good. Thanks very much. You know, where I've seen it work best is where the organization, that is the private sector organization, considered as a whole org approach, it might start at the top, and probably most appropriately should start at the top in the C-suite, either with the board or with the CEO, and that it engages in the entire organization with accountabilities that cascade throughout. That is, so HR, if there's an employee relations department, ER, you know, if you have a dedicated team to conduct the investigations and the follow-up with them, of course, if you've hired external contractors to do that, you would engage with them. And really tying all that together, I think it works best where you have clear, sound policies in place that demonstrate support for this. Clearly communicated, the policies need to be clearly communicated. And from my experience, where we've seen it, where I've seen it work best is where you can demonstrate a prioritization for these matters that, in a busy workload, whether it's in a public sector organization where there's numerous complaints, or in the private sector, or particularly where you might have in-house investigatory skill sets available to you, they often are flat out busy. And so I think you need to communicate that is a priority. And again, where I've worked in that environment and where I've seen it work best is where those types of complaints rise to the top and are afforded that kind of importance throughout.
Thank you, Michael. And Sandy, how elaborate do these internal systems need to be for them to be effective?
That's a really good question. First of all, I'd like to point folks to the Canadian Standards Association Whistleblower Guideline. About 6 years ago now, a group of us approached the CSA and said, a lot of organizations want to have hotlines and don't know how. It's difficult, it's complex, or a lot of organizations have them and they're not working well. So we put together a task force of 25 people. Because our laws are such a mess, we didn't qualify to make a standard because there's no laws to base it on. But this guideline is a plain language guideline. It's about 35 pages long to go into what does it take to do it. And it's really a useful guideline. If folks, if we've got a way for our hosts to give people a link, or if people want to contact me, I can give you a copy. It's a great document. Turned out to be the most downloaded document they've ever produced. So that's good. As regards the complexity, it's my view, and the way we've always run our program, is that the simpler you can make it, the better. Michael makes really good points about the resources you need and the buy-in, and you need everybody, particularly from the top. Tone at the top counts here. Everyone's got to walk the talk. You can't just have it tick the box and it doesn't work. We look for a number of key pieces that you need. Number one, you need the mechanisms, the channels to provide this protected communication option. And folks like you and me, Emmy, who do this every day, the primary channels are going to be a web tool that people can report by, secure email sometimes, phone calls. We still get lots of surface mail, brown paper envelopes because it's clean, right? I put it in the post. Unless you can do my fingerprints, you're never going to figure out who I am. So you need those channels. And I've heard of people using SMS and other things. And there's lots of groups in developing countries who, by force, because whistleblowing in those countries is very dangerous, who've developed quite clever technological tools online and stuff. But you don't necessarily need all that technology, but you need the channels, first of all. The second thing is, exactly as Michael has said, you need policy and process to be built into your system, because we provide these systems for industries across the country and around the world. But if you have a phone and you don't have electricity, well, the phone may not work. If people don't know how to use a telephone, there's all sorts of things about the system. You can't just plug it in and say, there you go, you have a system. You need all those policies and procedures as to how we're going to do it, who's going to do it, how are you going to make sure it's fair, where's the oversight and the governance. And then I think the last piece that we would talk about is, I've mentioned it briefly, and that is that what we would call a speak up environment. Until you have developed a speak up environment, blowing the whistle is going to be a dangerous business. And we spend a lot of time with our clients. You provide the service, great, right? We've got a whistleblower hotline, tick the box. But to get people to know about it, to know how to use it, to trust it, and to get management to see the value in it is really the tough piece. And that's where you really need the buy-in from management and everybody else. Government, private, it doesn't make any difference. The fundamentals are the same across the board. It really needs to be, lastly, it needs to be simple and easy to use. So we focus a lot now on the whistleblower journey. What's it like trying to do this? How can we make it easy? How can we make it less scary? How can we make it simpler on the other side to get the report, to do the right thing? And let's not forget about anonymity and all the things the organization's got to do. Once you've got it, there's a whole bunch of stuff you've got to do to make sure the information is used properly, the whistleblower is protected, And the last piece I would say would be transparency. If you have a system that people can't really see how it works or who runs it, where's my report going to go, you've got a problem. You've got to have transparency, and to the extent that you can, you need to be able at the end of a case to say, well, this year we've had this many complaints. We've heard Jordan and Mary talk about the American government. We've had this many complaints, this many were justified, this many resulted in, we can't breach the privacy, and I know we're going to talk about that later, of people who are accused, as well as protecting the whistleblowers, but we need to be able to show folk, here's what it is, it's not secret, it's open, and that's another way that transparency will help us to get buy-in, to really bring these systems to life, and to get people to trust them enough to use them.
Thank you. And thinking about how the information coming through those systems is actually actioned. Question for Paul: how connected to governance oversight, such as the board of directors, do whistleblower systems need to be to result in the desired action?
Yeah, thanks, Emmy. And building on a lot of the stuff that Michael and Sandy have already talked about, I mean, I can't overemphasize how important it is that your board of directors is seen as driving an effective whistleblower system. Because, from what I've seen, the senior management team always takes its cue from the board and then down through the company. So you're really setting an effective tone from the top. Now, the board of directors should be asking questions like, how effective is the whistleblower system? How is it being communicated? How are the policies approved? And they should want to see the reports that are coming in, at least at a summarized level. They should be asking, how do we compare against the benchmarks in terms of number of reports that are coming in? What incentives are provided to encourage reporting? And how are you rewarding strong ethics and compliance in the organization? These things, really are best done and driven by the board of directors. So, what I would do is I would report quarterly to the board of directors on all of these items. And, and if I have a significant hotline item, I would actually call the audit committee chair directly and not wait till the next quarterly report, so that they're seen as very involved in the process. And I can honestly say that you won't see systemic change in your organization unless the board of directors is really showing that they think this is critical and that they want to see the information. And at the beginning, this might be more of a push than a pull. I found that, at the beginning, some of the board members may not really know what an effective whistleblower system is. So you present this information and then they start to see, and then they go, okay, we really, really want this. And so that becomes part of that kind of governance process. Another thing I would say too is that, with the focus on ESG today, it's just critical. And so your board has to be seen as driving this. And it's not just on the corruption items, but it's that whole, range of things, right? Social, environmental, harassment issues, which are so topical. So your board has to be seen as really taking the lead on this. And as most of you probably know now, if you're not effective in your ESG, understanding and reporting and governance over those things, it's going to affect your ability to attract customers and attract financing. So it does, at the end, hit your bottom line.
Emmy, if I might just add one more thing, I agree with what Paul's saying. And there's one other circumstance we see a lot now with organizations that do have boards. We're also trying to involve them or someone like maybe chair of audit committee or somebody in the board in senior level complaints. Because if you have a system that's run by a body underneath management, and then you get a report about someone very senior, the CEO or someone like that, you've immediately got a really crummy problem where you've got juniors trying to investigate the boss, and that doesn't work.
Yeah.
And one of the ways for organizations to have a credible way to deal with that is to have the option of having a board member being one of the people that deals with those kind of reports. And so it's a key of our system that, you check who's going to get this before it gets released, right? And will the whistleblower get outed? but also how can you effectively investigate this if it's the top level of the company? You need someone like the board, as well as a governance role, to have them in some circumstances with an operational role in the processing and the follow-up and the investigation and the resolution of the complaints. And that's also impacts the governance side too. But it's not just governance.
Great comments from you both. Thank you. So clearly the importance of the board in being behind the program and supporting the program, but also in the investigative response in some instances as well, as you both outlined. Michael, could you share with us your thoughts on whether or not whistleblowers should also have a direct reporting route to senior management? So for example, compliance or others in the C-suite or executive management team.
Well, just to build on what, thank you, Emmy, just to build on what Sandy and Paula both said, I think one key thing, and what I also have seen is the importance of having someone, to Sandy's point, perhaps a designated person on the board where that information, should it be a senior person who is the subject of the investigation, that whoever is conducting the investigation has a direct contact to that person. That should be clearly established. Oftentimes you'll see senior people are the subject of the, whether it be an anonymous or an employee has come forward, a complaint that identifies misconduct of a type. So I think that's really key. Should I think Paul touched on this, should it go directly to the board? I think there needs to be a layer between the board and the actual body doing the work. And that, typically is, from, again, past experience, it might be the chief auditor, it might be chief legal officer, or chief compliance officer. There needs to be a filter, I think, so that there is some protection afforded for those individuals who have stepped forward and given their name. I think it's important to demonstrate that as part of the process. It goes back to I think the original point about designing and giving real forethought to what your program's going to look like, and you can adapt it as it goes forward. But I think the best case would be to do forethought and ensure that there is built-in protection.
Thank you. Just going to share a question that's come through in the chat. How should incentive programs operate within an organization? So maybe borrowing a little bit from how the securities commissions incentivize whistleblowers, how could that apply in a corporate setting?
I'd be really interested to hear from my colleagues on the panel about this. I think that my broad experience would be that it's very, very difficult and very, very unusual or rare that in a private sector organization, or even most governments, that, in other words, in the broad body of our industry across the country, that rewards of whistleblowers, as we said earlier, tend to be restricted in this country now just to the stock markets and regulators. And so typically within an organization, it's very, very difficult to compensate whistleblowers. Sorry. Having said that, there are things that we see companies do, like Paul talked about, how do you reward ethical and good behavior? And I don't think that that's about a monetary reward, but another way to look at it. I've seen organizations in Canada with really good systems where they will, for example, relocate a whistleblower if they're suffering retaliation, or even help them find a different job and help them. Mary talked about that compensation for your career. I'm sure we all know that many whistleblowers end up with the most terrible problems and might never work again in that industry or at all. And so some of them have got programs to try and compensate them, practically speaking, not financially, for that loss of employment. But I'd really like to hear what everyone else said. That's my experience. It's not really an issue in the vast majority of organizations in this country.
Yeah, I agree, Sandy. It's a difficult one, but one that actually is listed at one of the hallmarks of an effective compliance program by the DOJ SEC is that you have incentives. So you've got to find a way to do it if you want to be a leading organization. And we struggled with this, but we did find some ways. And one of those ways is really just finding a way to put it in your performance appraisal system, where you're really acknowledging people that are leaders in ethics and compliance. So an example is, you know, a manager that takes the time to train all his staff about, you know, compliance policies, whistleblower systems, get it out there, make sure everyone understands it, make sure they're the, you know, the first group to be signing off on the policies annually, that they're reaching out to third parties. For example, we found that a lot of our good tips came from third parties. And it was groups that were reaching out to the third parties, their suppliers and everything, and saying, here's our policy, make sure you know it. Here's the whistleblower information. If you see anything from our employees, let us know. And then we got tips from them. So finding a way to acknowledge those people within your company that are doing a great job of communicating and training, I think is the best way to incentivize.
Emmy, if I could comment. First of all, I agree wholeheartedly with Paul that they're finding a way to appreciate people who speak up and report problems is critical for every organization. I disagree slightly with Sandy. I think that I don't know how complicated it is. At the end of the day, we reward employees with extra bonuses and promotions and lots of things for doing what we want them to do in an organization. I do not think it's mission impossible to create an award for an organization. It could be even an anonymous award. So no one actually knows who got it, but someone got an award where they got paid something, or you know, smaller appreciation, you know, where you know, the chairman writes a note thanking them for exposing a particular problem. Whistleblowers are human. They like to be appreciated. They want to do well. They want the organization to do well. And so I think there's more ways that can be found and are found. The money problem is people, it doesn't have to be huge money. I know people are excited about winning $500 bonuses. So it's not about the money as much as the appreciation that's behind the money. I have two observations based on what people have been talking about here. One is, in my experience, the reporting gets lost in the middle of the organization. It's not the hotline where tips don't make it to the right people. It's people reporting to their supervisors and things like that. The SEC says more than 80% of the stuff that's reported to them was reported internally. And I can tell you that most of that happened and was lost in the middle of the organization. So as you're thinking about your systems, I'd be sure to try to capture that informal raising of concerns. And the second thing I would tell people is that like parents who think their children are all beautiful, every organization tends to think that their policies, procedures, and culture is perfect. And my answer to those organizations is, your children are probably beautiful, your policies may be great, but the best way to prove it is to have an independent survey to test whether awareness of wrongdoing, people's comfort in reporting wrongdoing within your organization. Because when I've conducted surveys across the financial service industry, it's been deeply troubling. And so I think doing those independent surveys is going to help you kind of understand truly what's going on in your organization, identify some areas where work needs to be done.
I really like the sentiment underlying the question, because I think it's exactly right that there should be some creative thinking around how do we change the culture from one of snitches and daubers to people who are, and I think we're seeing this in social behavioral science field. Let's talk about whistleblowers as forward indicators of risk. Why are they whistleblowers? They often are head of internal audit. It may just be part of what their job responsibilities are. So to Paul's point, absolutely, your performance evaluation should look at risk management. And one of the things of risk management should be, you know, speaking up about wrongdoing. And I guess on the flip side, we're starting to see for companies where it was just last week, Boohoo, which is a fast fashion retailer in the UK, they as a result of some corruption going on, they tied the executives' compensations to their performance on ethics and compliance and whistleblowing. So I think there's a lot that you can do in positive, but I think the best thing you can do is hire former whistleblowers. What says more? There's a huge brain drain that happens. Jordan and I have had the privilege of having some of the most talented people come through our doors, and then yet, you know, then they're the most well-intentioned and have been trained to the top levels, and we have an enormous brain drain. What says more that you like whistleblowers than to hire someone not just as your ethics and compliance person, but just, you know, as your tax enforcement or anything. There's so many of them. I think there's just a lot you can do to have positive signaling that you appreciate whistleblowers and that's your culture.
There's one other thing. There's one other thing. I'm sorry, Anka. There's one other thing. I think you want to penalize people who are aware of wrongdoing and don't speak up, because surveys show lots of people know about problems. And if the organization says, if you know about wrongdoing and you don't tell us, there's a consequence, more people are going to speak up.
Yeah, it's the cultural thing, I think, is part of what we're dealing with here in Canada. I think that Mary was right, that being a Commonwealth country, there is this icky sort of thing about paying whistleblowers until you say, well, look, what else happens to them? They just get ruined. But also, I think that we have, what Jordan says is right. I think we've got other cultural issues. And we know the work I do with the Centre for Free Expression Whistleblower Initiative, a lot of it is about trying to make the public aware of who whistleblowers really are, the most ethical, the people that can't leave it alone. They're the ones that say, no, we've got to fix this. And so changing people's perception of whistleblowers, helping them to understand who whistleblowers really are. And I love this hire whistleblowers idea and campaign. It's something that we've got to get on here in Canada. And we have seen things change over the last 6-7 years. Whistleblowers are viewed differently, but we still see lots of the myths and the misconceptions and the use of criminal terms to define whistleblowers, which is not right. We do have a cultural issue here, and we do have to find new ways to do it. And we can learn from other countries and programs like that you guys have brought to this. We've got a lot to learn. And as I said before, a lot of these are quite straightforward best practices. We're beginning to see very clear examples of what the best practices are from other countries, and we need to bring them here. And that's what we're trying to do with the Whistleblower Initiative, is really find ways to say, look, other countries are doing this. It works. Let's bring it here to Canada. But it's sadly a bit of an uphill battle.
Can I add to both Sandy's and Jordan's points? It's both the incentive, both the penalties for not reporting, but also we have to look at how do we ensure the protection of those who come forward with their concerns, who come forward with wrongdoings, and those who participate in an investigation, like witnesses who might be interviewed during an investigation into the alleged wrongdoing. We spoke about, like Sandy spoke about, the effective systems and the channels of communications. Like all throughout, we have to ensure that the personal information, the data, all the information that's being disclosed is protected and is adequately protected, because it's sensitive information. It may harm significantly the individual who's disclosing. It may harm the witnesses who will come forward, and providing a system internally that will protect these individuals and will protect them from reprisal, will protect them from keep their anonymity if that's something that they are looking for. All of these throughout these processes, it is very important, and it may incentivize in some ways people who know of wrongdoing to come forward, because they know they will have that protection from the organization.
Lots of great responses there. Thank you, everyone. A few other questions coming through the Q&A that I'm just going to pose to the group. The focus is on financial wrongdoing. How should other wrongdoing, for example, health, environmental, etc., be handled? So from a reporting aspect or the systems or sort of how they're dealt with, are there any differences based on the content or the nature of the information that's coming through?
Thank you for your question, Alan. I think that's a really good point. My experience has been that a lot of the whistleblower systems that we have been built out of and tend to focus a lot on financial wrongdoing, and a lot of private organizations that have them. that's the way that they focus. But what we've seen in the last few years is a big change in that. And I know in our practice, for example, when Me Too happened in the US with Weinstein and all of that stuff, and we began to see arts organizations in Canada really interested in understanding how whistleblowing systems could help in sexual harassment and cases like that. And more recently, and I know Emmy's team is very involved in this, people are beginning to see how whistleblower systems can also be relevant to the diversity and inclusion discussion. And if we look at COVID, we were asked to speak to the COVID-19 Long-Term Care Commission, where whistleblowing was a key issue. And the point you're making is a great one. Whistleblowing is important. It is the best and the most effective way, as we've heard from Jordan, across all channels, whether it's transport safety or misuse of government funds or sexual harassment or inclusivity. It works all the way across the board. I think historically it's come from a different place, but we're spending a lot of time trying to show people how once you have a protected channel, you can use it for all sorts of things. You've just got to understand how to make that work effectively. But a lot of organizations are very, very rigid in what they will or won't accept through their whistleblower hotline. That doesn't mean it can't be done. I'd love to hear what my colleagues have to say on the panel.
Yeah, I could just jump in. I totally agree with that. And the way that we handled this question, and it actually answers a piece of another question here, is that we changed the name of the whistleblower hotline to the business conduct hotline. And so everything within our business conduct policy was open to be reported on. And we encouraged people to report through the hotline on any of the items within our policy. And so we did get harassment items coming through and environmental items coming through. And the way that we handled that is that we had a very well established process for dealing with each of those items. And harassment items would be dealt with. We engaged with HR and dealt with that. And environmental items would work with the operational group, but we'd still have an oversight group that would make sure they're dealt with properly. So yeah.
Emmy, I would just add that to Alan's question, going back to the incentive-based programs, remember our programs have evolved in the United States. We now have a Department of Transportation program, which has nothing to do with financial fraud, has everything to do with safety. It's managed by the Department of Transportation and our National Highway Traffic Safety Administration. There's actually legislation circulating right now as a result of, we represent one of the Boeing 737 MAX whistleblowers having an identical program in the FAA. So we are sort of expanding beyond that area, recognizing whistleblowers do more than just point out financial frauds. But to pick up on something that Jordan had said earlier, there's a task force in the SEC that's focusing on ESG issues. And so in that press release that Jordan's talking about, we hear about basically attracting whistleblowers to point out greenwashing. So there's an environmental aspect to a lot of us now hold portfolios where we've cleaned our portfolios of polluters, big carbon footprint companies. And so if you're greenwashing, then that's a material decision as to my decision to buy that stock. So we're seeing environmental issues creeping in and being an enforcement priority in agencies where it doesn't necessarily on immediate first glance dovetail, but we're seeing it.
One good example of kind of the power of these programs and how they expand beyond what you would think is that more than 5 years ago, the SEC began prioritizing policing secrecy agreements, things that discourage people from reporting wrongdoing, confidentiality agreements, etc. Employment, when people leave their employment, that they basically said that you couldn't report on things that associated with your work. The SEC began prosecuting those companies. Those agreements impacted people's ability to report federal, state, and local violations of all sorts, whether they were environmental, Me Too, securities violations. And so even though the SEC was probably more focused on the securities violations, the very agreements themselves helped lots of other areas.
It's really interesting to see. I love Paul's example of changing the name of the program, and we have a lot of clients that do that. And someone's asked another question about changing the name of the program. Things that we've all wrestled with, I'm sure. I'd love to hear from Mary and Jordan about. Lots of us have tried to find a different way to use with the term whistleblower, but no one's ever really succeeded. Disclosure. There's all sorts of ideas about what you might do, but in the end, we've decided that the best way to go around it is to try and rehabilitate the perceptions of whistleblower. Mary and Jordan, would you have any thoughts about the term itself?
I know we've talked about, I think we've seen and this is your area of expertise more than mine, in internal reporting systems, they use the term speak up, and then the corollary is listen up, right? So that takes some of the heat out of it. I do think whistleblowing is a loaded term. I think you could say truth teller. We just haven't found anything necessarily that's going to stick. So I think the emphasis obviously should be more on, there's no question. I think when we talk, this goes to this issue of signposting. How do you call it? There's no ambiguity about whistleblower, right? If you use the term whistleblower, then we know what it means. And signposting is really important. So when you say Office of the Whistleblower, there's no question anymore where Harry Markopolos, who is the one who exposed the Bernie Madoff scheme, and the SEC ignored him. The idea was that there's something called an Office of the Whistleblower moving forward, so his information wouldn't be ignored. So you know clearly where to go. So I think we're kind of stuck with the term, and I think we do our best to change the culture of around it.
Thank you.
I think externally, whether you call it whistleblower or you come up with a new improved term, everyone's going to know what they're doing is dangerous, risky, and they're going to. So externally, I don't think it matters. And so in my world, I own it, and my clients, I encourage my clients to own it. Internally, I think that's different. And I think that what Mary suggested about focusing on the act, speak up, or other things is wise, because it shouldn't be, a career-defining moment to tell people what they asked you to tell them about within their organization. And so I think that I would focus, if I were an organization, on trying to focus on ways to just encourage people to talk.
One last question in the Q&A referring to the filter layer and where that should live in the organization. So what degree of independence should that officer have? So for example, should they report to the CEO? Does it matter?
I think it does. I think it does. I think I touched on it, and I think Sandy and Paul both have mentioned it, or at least touched on it. I think that filter layer, and it kind of has and if I use that term, I didn't mean it in a way that it's in any negative way. It was more about protecting individuals who are coming forward. But I think that from my perspective, it should exist. The line of report should exist outside for the purposes of administration of the program. So maybe if the board has and I think Paul mentioned this, an audit person, then it should be that person for that specific role. I'd be interested in hearing what others think, though.
Yeah, I think it's important that it go to individuals that are reporting directly to the board of directors. So in my role, I was reporting directly to the board of directors. And in fact, it's even stronger if you have two individuals that are reporting directly to the board of directors and both of them receive reports. So if you have the head of audit, for example, and the chief compliance officer both receiving their reports, then that stops, of course. If one of them is named in it, you want to make sure that there's somebody else. So it gives you that ability to have that independence, but then both are unfettered in terms of reporting into the board. So it gives that ability to do that. And I would just add to this, because I think we touched on this before. This has to be both the case, whether it's the anonymous report coming in, or whether it's something that comes in, just bubbles up through the organization. I think it should always go to those same two individuals, so that you've got that established process regardless of which system it's coming through.
Yeah, I would agree with that. We would tend to recommend a small team, and they quite often do come from internal audit, if you've got them, is a good one because they have reach across the organization and they're looking around at stuff anyway. So it's useful for gathering information. Sometimes it's legal, sometimes it's HR, sometimes in smaller organizations, it's somebody that has the experience and the knowledge to do it. But I agree, a small team that deals with the immediate reports, and then also a governance level to make sure, as you said, that they're getting reported up even at a filtered version of it, that people know how many we've got, what they're about. And so you've got checks and balances over that small team that's going to actually deal with the complaints. But that question is a perennial one, and it varies by the organization itself. You know, what resources do they have and what people do they have?
If I may draw an analogy, there is in the GDPR in Europe, there is the data protection officer role that is responsible for anything related to data protection within the organization and responds directly to the CEO or the highest level of the organization. So that could be a similar filter layer or role within the organization that's responsible for whistleblower complaints, where they would be the person who is first informed and would respond to the CEO, and they would have protections within the organizations themselves. Under the GDPR, there are protections in the law, but the organization could create those protections for that whistleblower officer. Let's call him that.
That's very interesting. And just to chime in as well, agree with you, Sandy, we're certainly seeing more and more of the committee approach to dealing with these types of issues, having a small group of people that, you know, are diverse enough to have enough viewpoints from across the organization. And just to touch on what some of you were saying earlier as well, that is really helpful in the sense that we're seeing so many more complaints that are multifaceted. It's no longer just, you know, financial misconduct. It's often financial misconduct in addition to bullying and harassment or something else. So it can be really tricky sort of trying to parse it out and figure out where it should go when you're dealing with so many allegations rolled into one. On a related topic, we've talked a lot about sort of encouraging people to report and the getting of information and enticing people to provide it. But would love to hear from you, Paul, and others about the importance of the investigative response and how that plays into both having people come forward and report, but also in the effectiveness of the system overall.
Yeah, I think, you know, as most of you know, whistleblowing was mandated, at least for U.S. listed companies with the Sarbanes-Oxley Act. And so I think there's a challenge to overcome this perception that people have that, well, it was mandated, and so it's just a check the box exercise. Yeah, they had to put in place a whistleblowing system and policies, et cetera, but they don't really want to hear the bad stuff. They don't really want to take this seriously. And so it's a little bit of an uphill battle to overcome that. So I think this is really critical to make sure it's not perceived as a check the box exercise. So you have to be willing, and I did this several times, to drop everything at a moment's notice. I'd have calls coming in where, you know, someone who would drop a letter onto the president's desk in Singapore, and I'd be dropping everything and getting on a plane and going there literally within a day. So you have to show that you take it very seriously. And showing up in person is really important because it sends an immediate message to everybody that you want to know what's going on. And also letting people know the outcome of your findings. You know, one time we fired somebody for demanding kickbacks, and I shared it with the office within a few days. So it showed that we investigate quickly, we take action, including dismissal, and we communicate it every time. And I think one of the important things too is that this creates two-way communication. You know, you get feedback from employees, you're providing them information, and the whistleblower hotline is one of the few instances in an organization where you get that really strong two-way communication. In terms of resourcing, I think it's been you know, highlighted here that you don't have to necessarily have, you know, this group of resources ready to go at a moment's notice. That's very expensive. One of the things that we did was we leveraged, one of the big four accounting firms who have offices all around the world. And so, you don't have to wait to jump on a plane to get the investigation going. So, we would call them, they could go in and they could grab a PC or a mobile phone to get data information immediately and start the investigation, and then I would arrive and pick things up. But I think you need to have an agreement where you've got the resources available, but you don't have to have them just sitting around and waiting.
I just want to follow up on one thing Paul said. The feedback to the person reporting or showing that you care, you're doing something, decreases the number of people who report externally. If you're a whistleblower, you're deeply troubled about something, and you tell the organization, and then they don't tell you anything, your assumption is they're not doing anything, and then they're more likely to report externally. And that seems particularly tragic if the organization is handling it appropriately. So that follow-up is important. And I hear organizations sometimes say, we don't talk about personnel matters, we don't do this. There's a way to communicate that you care, that you took action, that the type of people you brought in, and if there's any remedial procedural program.
Thank you. Any other thoughts in terms of investigative response? Okay. So you touched on it just now, Jordan, and we've been touching on it throughout, sort of this risk of people going outside. I mean, that is a big element of having a whistleblower program in place, is to ensure that the information comes to the right people in the organization so that they can deal with it. In addition to people reporting issues outside of an organization, what are some of the other downside risks of not having a robust program in place? And I would throw that out to anyone on the panel that has a view on that.
I think my sort of big picture view is that the primary reasons people decide not to make a report is either that they think that the organization won't do anything, or they believe or suspect or know that the potential cost, the risks and the downside and the retaliation is too much. And so exactly as Jordan has said, these surveys where you get people to tell the truth about what's going on without reporting people, and what people knew and how would they do it, show us clearly, wrongdoing goes on everywhere in all organizations at different levels. With all the weight there is against the idea that standing up and being counted and saying, excuse me, I want to raise my hand, the risks are so severe that my view is that if you don't have a dedicated and robust and supported system, really you're looking at a situation where you're accepting that most of this will never get reported. And that's what we talk to a lot of people about, is you may get little bits and pieces through your system that are not very important, but if you build trust in the system and it works, when that big thing comes down, when it is the theft or the corruption or the environmental disaster or the chairman harassing people sexually, whatever it is, if you don't have a system, the reality is you're allowing the law of the jungle to work, and to be the sort of overriding dynamic in a workplace. So it's a sort of abdication of responsibility, in my view, if you don't do it.
Yeah, I would echo that as well. I think being blind to the operational risks that not having this kind of program it would expose an organization to is really a recipe for being ambushed. As Jordan has pointed out, they'll go external and you'll wake up and read about it in the local paper.
Yeah, and I think also the stats are that companies that have an effective whistleblower hotline program in place have much less fraud in the organization. It's a massive internal control. And it's one of the reasons that I spent so much time communicating the whistleblower hotline, because it is the #1 control you can have in an organization where, you think about it, if you're a global organization and everyone around the globe thinks that everyone's looking at everybody else, that's the best internal control you can have. And so not having that just opens yourself up. in a massive way. And as I said before, that two-way communication, I found that this was so valuable, where you're going out and you're talking to people, in every office around the world and saying, we want to hear from you. Like, we really value what you think and what you see. And so, I would get calls all the time from people. Hey, Paul, you were out here and you're saying that I saw this, you should look into that. And I go, oh, that's great. And we would just have, it was almost like an ongoing dialogue with people around the world. And if you don't have that whistleblower system, you lose that. So I think for all those reasons, it is absolutely critical.
I think that the research that Paul is referring to, I think, is worthy of underscoring here. And I hope, Paul, I'm talking about the same, but there was a study done by two graduate business school professors in the United States, Kyle Welch from GWU and then Stephen Steubens from University of Utah. And they were given unprecedented access to all of NavX Global's internal reporting work that they do for companies around the globe. They're the #1 provider. And what their data showed, which is a rich data source, was that companies that have internal reporting hotlines that are effective, that are ringing off the hook, where people feel that it's safe for them to report, have fewer lawsuits, fewer investigations from outside sources. So really underscoring what Paul is saying, but why I wanted to underscore it is that helps you show that whistleblowers are not just a liability, they're an asset. Right? They are the canaries in the coal mine that have a positive impact on your bottom line. They are forward indicators of risk, if we want to give them a new name. So I just think that research is so important. It's so heartening for me to hear Paul internalizing that information, because that goes a really long way toward changing the perception of whistleblowers inside organizations.
Yeah, the other, thank you for that, Mary. The other study that's oft reported in whistleblowing is the Certified Fraud Examiner study, where consistently every year after year, you see that the duration of frauds, for example, and the losses and the costs of wrongdoing are dramatically reduced by organizations that have a whistleblower hotline system.
Thank you all for that. Another question that's come through in the Q&A, what to do when the whistleblower program receives non-genuine reports? Any thoughts on that?
That one is a very common question. I'm sure we've all dealt with that a lot. I would say two things. One, I have seen in my experience that there's a lot of fear about misuse of systems. And that we need to be careful that we're not allowing the whole thing to be written off because whistleblowers are out for their own good and it's only being used to get back at people. So we just need to be aware of that. That doesn't mean it doesn't happen, but the stats in my experience are very low. And the primary answer in my experience is having a good triage system. And that means you get the report in, and the first thing you do is we've talked about potentially this group of people with the knowledge and the training and the experience to deal with them, to say, what is this saying? Is there anything in here that tallies with facts that we can verify? Is there anything in here that we can clearly see is not correct based on what we know? Is there anything in here that really there's no way of verifying? And there's a whole series of questions that you can go through in your triage process to start coming to a conclusion about whether it's legitimate or not, whether it's pursuable or not, and how, in a typical world, we've heard Paul talking about the investigation side. As an investigator, what do you need to do? Where are you going to go with that? And the triage process, in my experience, is very often a great tool to flush out malicious complaints. But I would like to reiterate the idea that, in my experience, the percentage of malicious complaints is very, very small. And I'd like to hear what everyone else's experience is.
Mm-hmm. Yeah, I would echo all of that and add maybe a few things. First of all, when we communicated the hotline, we made it very clear what we need to be able to investigate. And so, we said, listen, if you don't give us enough information, it's really difficult for us to follow up. So we made that clear. And if we got reports in that seemed disingenuous and didn't have enough information, we had a mechanism. We used a third-party provider for our hotline. We had a mechanism to, respond back to them, even if they were anonymous, respond back to them and say, hey, listen, we do need this additional information. Can you provide it to us? And if they didn't provide it to us, then we would have to just leave it where it was. But like Sandy said, we were very careful about making sure that we looked at it through this kind of triage and understanding and following up as much information as we possibly could before we dismissed it.
There's another aspect which I think is worth talking about, and I'm sure that Mary and Jordan may be able to give us more information, and that is that typically a lot of organizations in Canada worked on this concept of an honestly held belief. And I believe that one of the better global best practices that is starting to creep in here in Canada is the concept of a reasonable belief. You have a reasonable belief that this is wrongdoing. And to the extent that you can go as far as dealing with and reprimanding or punishing someone who deliberately makes false or malicious reports, the standard that you are putting in your law or in your policies needs to be based on something that's pursuable. Mary? I hope I haven't put you on the spot there.
No, definitely agree. Definitely agree. I think what's interesting is there's now tech that is allowing, and not coincidentally, one of the solutions was created by a whistleblower named Sylvain Mansot, who allows for anonymous reporting. But Sylvain is a French speaker who was a whistleblower in an Australian construction company. And the technology, if you were to call the hotline, he was the only French accented person. So it'd be pretty clear that if he was anonymous, they'd still know who he was. So what I think is interesting is it allows sort of for this back and forth. So you can come in, you submit it anonymously, and then you can get, usually have some icon that's associated with you. And then I think hopefully what can happen is that you can have a back and forth. They can put information into that secure location, and maybe you can engender enough trust with this person that they ultimately will decide that they feel comfortable revealing their identity. So I think there's a lot that is going on, that the technological advancements that are allowing us to get more information and to more quickly suss out the wheat from the chaff. But it's absolutely been my experience that, in terms of frivolous reports, they're very few and far between. Nobody wants to sidetrack their career to put in things that are frivolous. So they certainly exist, but I think it's certainly the minority.
Thank you all. Probably have time for one more question, which I would like to direct to Anka. If you could share with us how whistleblowers in Canada are or are not protected.
Of course, I was on mute. It had to happen once, right? So the Canadian privacy, so I'll attack this from a privacy data protection perspective. And I will speak just briefly about the public sector protections, because those are, there are a number of federal and provincial legislation that generally protect whistleblowing reports and that govern the disclosure to the public. Disclosures to the public may be protected, but there are very stringent criteria that usually have to be met. So, for example, if there is an immediate risk to the public health or safety or to the environment, then it would not be disclosed to the public. But otherwise, they're fair game. And while certain statutes or federal statutes in the public sector will protect the identity of the whistleblower and witnesses that participate in the investigation, these provisions are subject to exemptions, and these exemptions arise from the operation of different acts and rules of law. So, for instance, if somebody may be protected for during an investigation, the whistleblowers and the witnesses may be protected during the investigation. If, for example, the alleged wrongdoer will file a lawsuit with let's say, contesting the report, the identity of the witnesses and the whistleblower may be revealed in courts because of the open court principles. It has been contested, it has been upheld in certain situations, but it's not a given, it's not something that's automatically protected. In the private sector, however, there is a legal gap, and there are a few statutory provisions that protect whistleblowers, and there is no general framework for the protection of disclosure to the of public interest information in the private sector. For example, under PIPEDA, which is the federal privacy legislations, and there are employees protections, but it only protects the personal information of employees of federal works and undertakings, which in Canadian that means banks, railroads, telecommunication companies. Employees are protected in 3 provinces, in Quebec, Alberta, and BC, under provincial legislation that has been deemed substantially similar to the federal privacy laws. But this leaves a gap in the protection of employees in other provinces. So for example, in Ontario, Manitoba, Saskatchewan. PIPEDA, generally speaking, is a consent-based privacy law. So organizations covered by PIPEDA must obtain the consent of an individual before they collect, use, and disclose personal information of that individual. So any organization that would receive information from a whistleblower would have to comply, or an organization subject to PIPEDA would have to comply with these obligations under PIPEDA. But there are limited exceptions that allow for the organizations to collect and use information without the consent of individuals when there is a breach of an agreement, or investigating a breach of an agreement or a contravention of the laws of Canada. But you can see there are limitations here in the whistleblower context, because there may be that alleged wrongdoings would not be in violation necessarily of an agreement or even a law of Canada or a province. It may be ESG violations or ethical violations that are not necessarily enshrined in law. So another thing that should be highlighted is that individuals have rights to request information about themselves that the organization has. So for example, a disclosure about a wrongdoing related to an individual may be disclosed upon the request of that individual to have access to the information. It may still be that the information of the whistleblower is protected as a disclosure, but it can create a risk that the disclosure will be identified nevertheless. There is upcoming legislation in Canada. Hopefully, PIPEDA will soon be amended or replaced rather by the Consumer Privacy Protection Act, and it includes similar provisions with respect to the issues that I've just discussed. And one thing that will be added, though, it's a system for codes of practice or certification programs, where organizations may choose to voluntarily comply or maintain a certification as a business measure. And this would help shield the organization a little bit from the wrath of the new privacy commissioner, or the powers that the new privacy commissioners and the new legislation will give, and the fines that might be lodged against violations of the new legislation. If that comes into effect, we'll see. Provincially, there's a mishmash, there's no consistency. There are certain protections under Personal Information Protections Act in Alberta and BC. There are similar protections under the Health Information Act. Quebec is proposing new legislation that will include express protections that prohibits reprisal for someone bringing a complaint or cooperating in an investigation. this is similar to the California Consumer Protection Act, in where it is prohibited to discriminate against somebody who presumably encompasses also the protections for whistleblowers for employees. This is a 5-second overview of Canadian privacy laws and data protection, which is, I try to synthesize whatever was most interesting and important for the whistleblower discussion, but there's a lot more, and there is a lot coming down the pipe, hopefully in Canada soon.
Thank you, Anka. That was a very great summary. And I'm sure that we could all go on for a lot longer, but we're just about at time. So I want to make sure that we leave a few moments for closing remarks. So I would like to turn it over to James Cohen, who is the Executive Director of Transparency International Canada.
Thank you very much, Emmy. Can you see me? Yes, there I am. And you can hear me. Thank you very much for organizing the discussion. Very thorough review of whistleblower protection and establishing whistleblower hotlines and mechanisms within Canada, from the legislative aspects all the way through working the system within a company, even looking philosophically at the term whistleblower and can we change it around? What do we need to do about it? And how to incentivize and protect those who bravely come forwards to bring information to us. So at the end of the day, as a lot of the panelists pointed out, really they just, whether there is incentivization or not, just want better, whether it's better internal controls, environmental protections, better standards by government and companies to uphold the values that they all claim to abide by, and the rules that we all want each of us to follow. So a hugely important discussion, a lot of experts who are pushing this forward. Thank you to all of you who are doing this. Thank you, Joe Weiler and the team at the Anti-Corruption Law Program, John Ricci, Norm Baldwin, everybody out in Vancouver who's putting this together. Always appreciate the work all of you are doing, volunteering to put this together at UBC, iClear, and of course with us at Transparency International Canada. I do not have access to the chat panel for all panelists, I think, or attendees. Oh, I do. So I'm going to be sneaky and just say that if you want to know more about Transparency International Canada's work and potentially support us, you can either become a member, and you can sign up here. Your organization can become a supporter, and you can learn more about becoming a supporter here. And if you would like to just skip the paperwork and donate directly to TI Canada and get your tax deductible slip right now, you can go ahead and make a donation to TI Canada to conduct so we can continue to conduct our work and collaborate with people like we've talked to on the panel today and our good friends out in BC and across the country to keep our work going. If you have any questions about TI Canada, you can reach me at ti-can@transparencycanada.ca. So on the West Coast, have a good rest of your day. Here in the middle of the country, have a good afternoon start to the weekend. If you're joining us from overseas, have a, well, bless you for being in late on a Friday night and going into the weekend. And I hope you enjoy your weekend. Please get vaccinated, everyone. Stay safe, keep distance, and I hope everyone stays healthy and we all get to see each other in person soon. Thank you.
Thanks, James.